Shri Anil Desai.
Chairman, sir, I rise to support the enforcement of security interest and recovery of debt laws and Miscellaneous Provision Amendment Bill 2016. So it seeks to amend 4 laws, that is SARFAESI Act 2002, Recovery of Debts Due to Banks and Financial Institutions Act 1993, Indian Stamps Act 1899, and Depositories Act 1996. By amendments which are brought in this bill to these 4 major acts, that is SARFAESI Act, all that is done in the legislation that it has strengthened than what it was earlier. The need to strengthen, that is obviously, as has been said by so many, all the speakers, that considering the position of our nationalized banks and the financial institutions, kind of debts which have come, debt mountain of around 8 lakh crore, and the kind of government which is doing its best to infuse capital into the banks to see that they are not seized off their credit line, and otherwise, I mean, which would affect the economic activity, which would come to standstill, to see that efforts are being made. But the things which need to be seen in the light of that, whatever aspect, I would stress one aspect that is which needs to be stressed upon, is the implementation and application of this new legislation in letter and spirit. As of today, sir, Indian insolvency regime has complexities in handling of the cases by various institutions, whether it is a High Court or a BIFR or even official liquidators. The institutional infrastructure, that is insolvency professionals, tribunals, and other related agencies need precise mandate, sufficient resources, and training to ensure that this new legislation is effectively implemented and the timelines provided in it are followed. The legislation is certainly a step in the right direction towards minimizing the delays and providing greater predictability for debtors and creditors in both process and outcomes. Here, RBI, even the RDD BFI, the act which has been amended to, where debt recovery tribunals and debt recovery appellate tribunals have been set, the act provides for that banks and financial institutions will be required to file cases in tribunals having jurisdictions over the defendant's area of residence or business. The bill allows banks to file cases in tribunals having jurisdiction over the areas of bank branch where the debt is pending. The bill also provides that the certain procedures under the Act will be undertaken in electronic form. That is a very good, that is online procedure which will be coming after this enactment of this legislation. So another good this thing is that the bill creates a central database to integrate records of property registered under various registration systems with this central registry. This includes integration of registrations made under Companies Act, Registration Act, and Motor Vehicles Act. The bill provides that the security creditors will not be able to take possession over the collateral unless it is registered with the central registry. Further, these creditors, after registration of security interest, will have priority over others in repayment of dues. So another thing is to the stamp, the amendment which has been brought for the stamp duty. Stamp duty will not be charged on transactions undertaken for transfer of financial assets in favor of asset reconstruction companies. Financial assets include loans and collaterals. The investment in ARCs that has been also provided for, the bill will allow a sponsor of an ARC to hold up to 100% stake in the ARC, that is asset reconstruction company. It will also enable non-institutional investors to invest in security receipts issued by ARCs and lays down a timeline for possession of the secured assets. Amending Stamp Act, no stamp duty will be levied where transactions undertaken involve transfer of financial assets in favor of ARCs. And for the exemptions to apply, such transfers must be for the securitization or reconstruction purposes only. The Depositories Act 1996, This bill also seeks to amend Depositors Act. Amendment in Depositors Acts have been proposed for facilitating transfer of shares held in pledge or on conversion of debt into shares in favor of banks and financial institutions. So, supplementing the aims of bankruptcy code that has been also provided in this bill, the bill aims to support the bankruptcy code, and several amendments are in line with its objectives. Debenture trustees are accorded same rights as that of security creditors, which aids in a level playing field for creditors. Banks and financial institutions are permitted to transfer financial assets to ARCs prior to them, they being declared as non-performing assets, which aids in the early detection and resolution of distress. So overall, this legislation will help the economy to grow, and the faster the mechanism would be, it would be beneficial to the entire economic activity. Thank you, sir.
Welcome. Thank you.